DNA District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J.
You may be seated. Court does call the case of the people of the state of Michigan versus Jerome Moore.
Good afternoon, Your Honor. Katie Ridgway for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sharon Moore, who's state your name.
Jerome Moore.
Thank you.
Christine Pajak also on behalf of Sharon Moore.
All right, thank you. You may be seated. All right. So date and time set for Frank's hearing, but things have changed. And even before you go on, I just want to express the court's appreciation for the hard work of counsel going through. I know it may have been a delay for the people that were waiting to see something, but your efforts were greatly appreciated. Ms. Rismus.
Your Honor, thank you, and I appreciate the opportunity to address the court. First, allow me to apologize to the court and counsel. I was needed unexpectedly elsewhere in another county on a special prosecutor case this morning that went perhaps a little bit longer than expected, and then as life unfolds, I was rear-ended in a gas station parking lot. Everybody is fine, but I really appreciate everyone's patience, and it was not intentional. Judge, I appreciate the opportunity to address the court about what has transpired and where we have arrived. This case, as is true with many cases, Your Honor, is alive and sort of moving and breathing. Investigation has been ongoing. An exchange of information has also been ongoing. As a result of all of that, where we have arrived based on what we now.
Okay, pause right here. This is a huge turning point in the case. The prosecution just revealed that the original charges are about to change. In criminal law, this often means investigators found new evidence or realized the original charges may not hold up in court. And trust me, when prosecutors start reshaping charges mid-case, something significant has happened behind the scenes. The big question now is this good news for the defendant, or is it just a strategic move by the state?
Is that we feel the most appropriate charges to address the defendant's behavior on December 10th of 2025 are two additional counts 4 and 5. We would be seeking to add a count of what we call malicious use of a telecommunications device in the context of a domestic relationship, and then an additional count of trespass. Those are, as Your Honor is aware, misdemeanor matters. Your Honor, we have arrived at that as indicated based on a thorough review of the additional evolved evidence and investigation, as well as after consultation with, pursuant to our obligation of the Crime Victim Rights Act, consultation with the victim, largely through her representatives in this matter. Your Honor.
Did you catch that? The prosecutor just admitted there isn't enough evidence to prove domestic violence. That's a massive development because domestic violence charges carry far more serious legal consequences. Instead, they're moving forward with misdemeanor charges. For viewers watching at home, this is a classic example of prosecutors following their legal duty. They can only charge what they believe they can prove beyond a reasonable doubt. But it also raises a question for you. Do you think this outcome reflects weak evidence or smart legal strategy?
One comment I would like to make specifically about the additional count of malicious use of a telecommunications device in the context of a domestic relationship, as this court is aware, but I would like to be clear for the record because of, I know, docket and calendaring purposes. Your Honor, we did not at the time of issuing initial charges in this matter, nor do we believe now after additional evidence has been presented to us, do not believe that there is sufficient evidence to prove a count of.
And there it is, the plea deal. Instead of fighting the case at trial, the defendant is agreeing to a no-contest plea. Now here's what makes that interesting. A no-contest plea means the defendant isn't technically admitting guilt, but the court will treat it the same as a guilty plea for sentencing. This type of plea is often used when there could be potential civil lawsuits later. So the real question becomes, was this the smartest legal move for the defense, or did the prosecution just secure a quiet victory?
of domestic violence in this matter, not historically and not what happened on December 10th. So we are obligated, as this court is well aware, legally and ethically and morally to not charge that which we do not think we can prove. What we do believe the evidence supports is criminal misbehavior in the context of an intimate partner relationship, and that is why that tag-on is on the malicious use charge. Your Honor, it is my understanding that pursuant to adding those counts, that there will be a plea as a result of that, but I leave that to counsel.
Did you want to say something?
Yes, thank you so much. I'd like the record to be clear that the negotiated disposition involves a dismissal of the 3 charges that had been charged. That was not mentioned in the recitation by the prosecutor's office.
That is absolutely correct. The end result of where we land by adding on the counts is that my best understanding is that the defendant will enter a plea to those additional counts, and in exchange for that, we will absolutely dismiss the originally charged.
That would be an entering of a no contest plea to count 4 and count 5 with the dismissal of count 1, 2.
All right, very good.
Thank you.
The court does have before it a plea agreement form that indicates that the defendant will be pleading no contest to the charge of malicious use of a telecommunications device with domestic relationship tag. That is a misdemeanor punishable by up to 6 months incarceration. He will also be pleading no contest to the charge of trespass, which is a 30-day misdemeanor. Upon his successful no contest plea to those charges, counts 1, 2, and 3 will be dismissed. That is the court's full understanding of the agreement. There is, however, one other thing that should be mentioned, and that is with reference to sentencing. The court is going to be given full authority, if the court deems it necessary after a review, to sentence under a deferred program. That is the court's understanding.
That is also correct, Jim.
That is correct.
All right, very good. Mr. Moore and counsel, if you could approach the podium, please. Okay, gotcha. And if I may have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give, the truth, the whole, nothing but the truth, so help you God.
Yes, sir.
What's your name, please?
Sharon Moore.
Mr. Moore, it is this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. The first charge is the added count 4 of malicious use of a telecommunications device involving a domestic relationship. That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
And also the added count 5 of trespass. That is a misdemeanor punishable by up to 30 days in jail and or a fine not to exceed $250. Do you understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about a no contest plea I have to make sure that you understand. First thing is that it first of all means that you're not further desirous or wanting to contest these 2 charges. Do you understand that, sir?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea, counsel.
The basis for the no contest plea is civil liability.
Potential civil liability. All right. very
Yes,
good.
civil litigation.
Got it. Sworn to the charge of, let's do it this way. Find the form. To the charge of malicious use of a telecommunications device, how do you plead?
No contest.
To the charge of trespass, how do you plead?
No contest.
But you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
I don't think he has executed any device and rights form, has he? I think he did, actually. I don't have it.
I believe he did
At arraignment, do you recall that, sir?
Not off the top of my head, sir.
Pardon?
Not off the top of my head.
I have one that I printed up just so we can continue. I did go over the advice of rights form with my client yesterday. So him signing it now is acknowledging that he did review it yesterday.
All right, is that correct, sir?
Yes, sir.
All right, I'll let you. Did you have any questions regarding any of the rights that are contained on that form?
No, sir.
All right. You understand that by pleading no contest, you're waiving or giving up the rights that are contained on that form,
Yes, sir.
particularly the rights that are contained under paragraph 5. You'll see a copy on the podium, which are your trial rights. You understand that you're giving up those.
Yes, sir.
All right. You understand you're giving up your right to appeal.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
The court has been provided and has reviewed thoroughly Pittsfield Township Department of Public Safety report for their case number 25-25629. Counsel, any objection to the court having reviewed that report?
No objection. No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these two offenses. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit any misconduct as defined in the Michigan court rules, you would first of all not be entitled to withdraw your plea. You understand that?
Yes, sir.
And also the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Is counsel aware of any promises, threats, or other inducements which have led to this plea?
There are none.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Court acts.
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 4 and 5. Counts 1, 2, and 3 are hereby ordered dismissed. A pre-sentence investigation and report is ordered. Sentencing in this matter will April 13th work for the parties? I have April 13th or April 20th at 11 a.m.
April 13th works for the defense.
Much better. Thank you.
Well, hold on one second. These are Mondays. I don't want Monday. I don't want a Monday.
You want a Wednesday?
I want a Wednesday. Okay. Hang on a second. April 8th, will that work?
I'm not available. I'll be in trial in Oakland County.
The sentencing will go smoothly. No. All right. April 22nd in the afternoon.
That's good for the defense.
Will that work for the people?
Judge, I personally will likely be unavailable in a trial, but it sounds like my office could make certain that it's covered.
Well, you've been here from the beginning. We might as well try to make it work for you too. Give me a special day then.
April 14th.
Will April 14th in the afternoon work?
That should work.
I'm checking. April 14th works for the defense.
April 14th, 2026 at
2 p.m.
2 p.m. Before me. Anything, Esteban?
Nothing. Oh.
Yes, as to bond, we are asking that the bond condition of a GPS tether be removed as a condition of bond for the following reasons. The tether was placed when it was the understanding that the charges my client was facing was a felony and a stalking charge. Now that those charges are dismissed and the narrative of my client being having a history of violence and stalking has now been proven to be false. It's our position that the tether is no longer necessary. There is still in effect a no contact order by my client to the complainant or by any third party to the complainant. He will absolutely abide by that no contact provision, and he has no intent to by himself or anybody else to contact the complainant.
All right. Any response from the people?
I will say that I am comfortable leaving the matter of the tether in the sound discretion of the court. I will reiterate that our victim's most fervent desire is that the no contact, either direct or through third party order, remain in effect, and that is her highest priority and therefore ours.
All right. What I'm going to do, and that provision regarding the no contact either by the defendant or a third party does remain in effect. I'm going to, at this time, however, deny the request for the removal of GPS tether until such time as the defendant has been interviewed by probation, and then I will make a decision on that based upon a recommendation from probation. All right.
Thank you for that consideration.
Thank you. Anything additional?
No, Your Honor.
Nothing.
Fantastic. Again, thank you both for your hard work on this and for getting it done. Thank you.
So much.
Court stands adjourned.